All right, right over here, you go left. All right, I think we're ready to start our afternoon court calendar. We'll do that by calling the case of the state of Wisconsin versus Damian Moreno, case 26 CF 1081. Appearances, please.
The state appears by Assistant District Attorney Thomas Valerio. Good afternoon.
Good afternoon.
Mr. Damian Moreno appears in custody in person with counsel attorney David Anderson. Good afternoon.
Good afternoon to you as well. You should have a copy of the criminal complaint.
I do have a copy of the complaint. We do waive any further reading. I do know that the address on the complaint is correct.
All right, and perhaps you've already filed a notice of retainer, but should we list you as counsel of record?
You may.
Very good. State of a position on bail?
I'm recommending a $2,500 cash bond in this case. I'm asking for conditions that the defendant not access the internet, that the defendant not access the app titled Telegram, and that he not have any unsupervised contact with minor children. I'll note that, as the court's obviously aware, these counts involve mandatory minimum prison sentences, which could create a likelihood to flee. I'll note Mr. Moreno is relatively young. My understanding is he's 21 years old today. I'm not aware of any criminal history, meaning I don't have any history of failures to appear. With that said, as far as a child porn case goes, it's pretty strong. Mr. Moreno admits to confesses that he was sharing CSAM material. Law enforcement seizes his phone. Inside, he's using that Telegram application to share CSAM material. There were 105 images tagged by DCI as CSAM, and many of those were entered into NECMEC. 73 of those were recognized as previously identified CSAM by NECMEC. Not only is there the confession, but it's also worth pointing out that Mr. Moreno is admitting to sharing these CSAM files with other individuals, which, you know, it's lots of times just folks who have child porn cases might only just be retaining them for their own use. Mr. Moreno is unfortunately indicating that he's shared them with others to fit in with others. That's what's alleged and according to the allegations in the police reports. So I think that cash is appropriate, and I think the non-monetary conditions are appropriate.
All right, thank you. And Attorney Anderson.
Thank you, Your Honor. Defense is asking for a signature bond in this case. No objection to the non-monetary conditions. However, I would like one alteration as it regards to accessing the internet. Mr. Moreno's job at work requires him to have some use of applications at work that are connected to the internet. I'd ask for a provision that allows for accessing the internet only while at work for employment purposes. As far as the basis for the signature bond, it is true Mr. Moreno is very young. He is 21. He has spent his whole life in Dane County. He is employed. He knew very well what was going on back in September of 2025 when law enforcement executed that search warrant. And he stuck around. He did not run. He complied with law enforcement. He has retained counsel. He is of no risk of flight or I believe even to reoffend. And so at this point, I'd ask the court to grant the defense's request for a signature bond with the modification on the non-monetary condition.
And I haven't reviewed the complaint at great length yet. I'm going to look at it before any decisions get made here. But are you indicating that there was a warrant served in September, but then the arrest just occurred here a few days ago in May?
That is correct.
Okay. And well, any response from the state?
I think things are different a little bit for Mr. Moreno as far as today's concerned. The cases are now charged. He understands the penalties that are associated with them. They're mandatory prison sentences upon conviction. I don't object to the alteration to the non-monetary condition defense counsel proposed, though.
This sounds more sarcastic than I mean it, given the circumstances, but you don't suppose he's Googled the potential penalties at some point between September and now?
I don't know.
Okay. All right, let me take a look at the complaint. I should get a better sense of it other than just the mere charges before making a decision. maybe just for the sake of the record, because I think there were a couple of acronyms used that may not be in regular everyday conversation. I'll just spell out what they are. I think there was a reference made to the CSAM, which is a generally accepted abbreviated form of child sexual assault material. And then also a reference to NCMEC, which refers to the National Center for Missing and Exploited Children. With that, I do have to turn to the bail issue here. In a lot of ways, these possession of child pornography cases are some of the tougher ones in terms of knowing what the right bail result is, because it, by basically any perspective, it's serious conduct. The legislature says it's serious conduct because of the effects on the individuals who are depicted in it, and I suppose sort of a societal, concerning shift towards societal acceptance of the behaviors that are often depicted in the images. The legislature has also spoken fairly clearly in terms of the seriousness of it by setting a mandatory minimum sentence. That is, if somebody's convicted of this offense, there is a mandatory minimum prison sentence. That's serious, and I think gets the state a pretty good chunk of the distance towards a successful cash bail argument. Mr. Moreno also appears to be in the same category of a lot of individuals who are charged with this offense, where they often don't have any prior criminal record. There's, in Mr. Moreno's case, he has the additional feature of being younger, which I suppose means a lack of record is a little less telling because he hasn't had as much time to build one. But at the same time, it also is relevant to ability to post bond. It's relevant to the issue of, brain development and decision-making capacity and things of that sort. I'm not suggesting that somebody at 21 shouldn't have an idea not to engage in what's alleged here. And on that point, they are allegations at this point. They haven't been proven in a court yet. That's the whole point of the process, is to get to the point of figuring out whether that occurs. It's also been my experience on these types of charges that while they're, for all the reasons we've talked about, taken seriously by the judicial system, there's very, very little connection between individuals charged with this offense and subsequent failures to appear. I'm not sure I could identify a crime for which the failure to appear rate is as good, and I mean that in a positive way, as for this offense. For whatever reason, and perhaps it's just because it's frequently individuals who don't really have a prior criminal record or experience with the criminal justice system, it seems like people get charged with this, the case is resolved relatively quickly, the sentence gets imposed, they serve it, and we just never have issues again. It's also, I think there's an additional factor in favor of Mr. Moreno that's strong, and Mr. Anderson identified it, which is that he's had 8 months to run from these allegations, had that been his choice. The state correctly points out that he now is charged in a criminal complaint. He knows this is real, that there's going to be charges, and he has some issues he has to work through here. My question earlier, notwithstanding, at some time between September and now, if he had an inclination that it made sense to run, he'd have done that, I think, and he hasn't. He stuck around, he was found locally, he's been brought here. It's, I think, given a bail statute that says for this offense that I have to really take appearance risk as the main factor in support of a decision, I think I have to make that decision in favor of Mr. Moreno. I'll order a signature bond for that reason. If the legislature included this in the list of crimes under Act 3, for which I would be permitted to take into account a broader swath of potential concerns or risks, this may well be a different analysis, but that isn't the law. And my job is to try to apply that. So I'll order a signature bond. I will order conditions that he not access the internet. I'm going to say that he not access the internet unless either supervised by a responsible adult or or at work for employment purposes. I think the exception described by the defense makes good sense. There's reasons, it's pro-social to remain employed and have the ability to remain employed while released on bond with a pending criminal case. I also can envision a lot of situations where access to the internet is necessary, and I think it's likely that he'd be able to have another adult present for that. I'll save you all the laundry list of things that we all do in our regular everyday life that are basically impossible or just part of ordinary living that require access to the internet. I will specifically adopt the condition that he not be on Telegram. And also, I think the unsupervised contact with minor condition is warranted given the circumstances. I'll adopt that as well. What about the time limits for preliminary hearing?
Judge, we will waive the time limits.
Sounds fine. We'll accept the waiver. We'll get it scheduled for a status conference. Mr. Moreno, please keep in touch with Mr. Anderson, make your court dates, follow those conditions. You'll make your way through this. Good luck to you.
Thanks. Have a good day.
Take care.
Williams is next, Carl Williams via Zoom.
Okay, I think we're ready to call the case of the state versus Carl Williams. It's case 26 CM 1097. May we have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio. I appear in person.
And it appears that Mr. Williams appears by Zoom video from the jail. Here in the courtroom for him, Attorney Clayton Kavanaugh.
All right, very good. I do want to make sure that he can hear us okay. Mr. Williams, if you can hear us, can you raise your hand or give us a thumbs up or something? Okay. Well, maybe I'll pause for just a second in the hopes that the connection regains. All right, now I can see some movement. Mr. Williams, if you can hear us, would you please raise your hand or give us a thumbs up or something? There we go. There's both. Thank you, sir. I appreciate that. So it looks like there is a probation hold. I did not get a chance to see what branch we should assign this case to, but I bet the clerk has it figured out.
Looks like it'll go to branch 2.
Very good. State's position on bail.
I have no objection to a signature bond in this case. I would ask that the defendant have no contact with Ariel M. Their first name is spelled Ariel. And I would ask that the defendant be banned from any place Ariel M. temporarily resides or occupies.
And Attorney Kavanaugh.
First, I would just note, because I don't think I got to it before, we've gotten the copy of the complaint. We'll waive its reading. The address in the complaint appears to be correct, and Mr. Williams is not eligible for public defender services. But regarding the bond here, signature bond seems to be appropriate on my review as well. And I see no reason why the non-monetary conditions would be burdensome, so we would stipulate.
I will order a signature bond with those conditions. And Mr. Williams, I'm sure you heard what Mr. Kavanaugh said about currently not being eligible for a public defender. You're always free to reapply with their office. You could hire a lawyer on your own. If you don't have the funds to hire a lawyer on your own and the public defender still says no, you could also apply at the clerk of court's office. Sometimes they can advance to a lawyer with like a payment plan. But you're good for today. Good luck to you. Take care.
Thank you, Your Honor.
You're welcome. Thank you.
All right, Connor next, Connors, forfeiture.
Hi there. Let's take up the case of Dane County versus Colleen Connors. It's case 26 FO 856. Appearances, please.
County appears by Assistant District Attorney Thomas Valerio. The defendant, Colleen E. Connors, appears in person in custody without counsel.
Okay, and I should just verify that you are Colleen Connors?
Yes.
Okay, very good. So it looks like you're holding a complaint there. That is not a criminal complaint. Instead, the DA's office decided not to charge you with a crime. The complaint alleges a county ordinance violation. It's basically a fancy version of a ticket. And the charge is disorderly conduct. You still have some rights. One right would be to enter a not guilty plea to that. If you enter a not guilty plea, we're gonna release you from jail today. You'd have another court date. You wouldn't have to post a bond or anything. And then that would keep open your rights to potentially have a trial on this or look into your options more fully. That's one option. Often, the county has some kind of a proposal to resolve the case for a fine of some sort. If you wanted to at least hear that and make a decision about whether that's an option today.
Yeah.
So you'd like to enter the not guilty plea? That's totally fine. We'll get the not guilty plea entered for you. Is this address on Verona Avenue the best one for you?
Yeah.
Okay, and then one other right we should talk about. As things are set right now, if you had a trial on this, it would be a judge that would make the decision instead of a jury. If you think you might want to have a 6-person jury decide the case. I know you're shaking your head no, but I want to at least explain the option so you know about it.
Okay.
Yep, if you think you might, within the next 10 days, you'd have to pay $36 in jury fees. If you don't pay the fees, you're not in trouble or anything. You'd still have a trial. It's just it would be a judge. Yep, but now you at least know both options.
Yeah.
So you're all set. Good luck to you. Take care.
Thank you.
You're welcome.
Torres Hernandez is next, forfeiture.
Torres Hernandez. Stand election.
All right, we'll take up the case of Dane County versus Marjorie Torres Hernandez, case 26 FO 852. Appearances, please.
The county appears by Assistant District Attorney Thomas Valerio. The defendant, Marjorie M. Torres Hernandez, appears in person in custody without counsel.
Okay, and just to confirm, you're Marjorie Torres Hernandez?
Yes, I am.
Okay, very good. So you should have a copy of a forfeiture complaint there. The DA has decided not to charge you with a criminal offense.
Okay.
They have charged you with a county ordinance violation instead. It's basically the same as getting a ticket instead of a criminal charge,
Okay.
but for disorderly conduct. You have some rights. One right is to enter a not guilty plea to that charge. If you enter a not guilty plea, you'll be released from jail today. You won't have to post a bond. You'll just be released.
Okay.
And you'll have other court dates that would keep open your right to potentially have a trial on this. Or at least look into your other options, maybe talk to a lawyer, whatever you decide to do.
Okay.
So that's one option. If you think you want to resolve this here today, they may have an offer for like a fine to resolve it, and then it would be over. But it would also be over. There wouldn't be the right to a trial or something later on.
Right. Question to that.
Yep.
Would it be the same as the other? Like I would be released today or I'd stay until.
Yeah, that's a great question. You would be released either way.
Oh, okay.
Yep. So really, it's up to you. If you think you might want to contest this or you want to defer the decision to a later time, a not guilty plea is one option. Or if you're pretty sure you want to just get this resolved, then the other option is certainly on the table. I should also tell you one additional thing. Either way, I think you're going to be still under that 72-hour no contact condition until sometime tomorrow.
Yeah.
So that applies. It kind of runs separately.
Yes, they did let me know that.
Mhm.
Thank you, though. I think I'm gonna. I'll probably go with the second option. I mean, I would like to go with the first option. I just don't know if I've never gone through anything
Yeah.
like this before, so.
So if you're totally unsure or you want some time to be able to maybe talk with somebody about the process or something, your safer bets to enter the not guilty plea, because then you just don't have to make a decision about much of anything here today, and all your options are still on the table later.
Okay.
It's really only if you were looking at this and saying, you know what, there's no way I'd ever want to fight this, and I'm sure that I don't really have much in the way of defenses to this, that you would want to consider entering the plea.
Okay. I think I'll just go with the second option.
Okay, why don't we actually hear the offer, and then I
Okay.
suppose you'll know the numbers and factor that in too. Mr. Valerio?
It's court costs only.
Okay, so if you took that offer, that fine would wind up being $214.50. So that's
Okay.
kind of what you're facing, the $214.50 would be the fine. You'd be found guilty of this non-criminal ordinance violation, but then the case would be over for better or for worse. Or you could enter the not guilty plea, either way.
Not guilty plea.
That's what you'd like to do? Okay,
Yes.
that's fine. We'll get that entered. Is this address on Walnut still the best one, at least after tomorrow?
Yes.
Okay, and then one other right I need to talk with you about. You have the right to a trial on this. As things are set right now, it would be a judge that would make that decision at a trial instead of a jury. If you think there's some way you might want to have a 6-person jury in the case, you have to pay $36 in jury fees, and that has to happen in the next 10 days. If you don't pay the $36, you're not in trouble. It's not a fine or anything.
Okay.
And you'd still have a trial later if you wanted it. It just would be a judge. So it's a way of keeping the option of having a jury open.
Right.
And you have 10 days to decide, so you don't have to do that now.
All right.
You're all set? Take
All
care.
right. Thank you.
You're welcome.
Pruitt is next. Pruitt. All right, there we go.
All right, we'll call the case of the state versus Takara Pruitt. It's case 26 CM 1109. Appearances, please.
The state appears by Assistant District Attorney Thomas Valerio.
And Ms. Pruitt appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading at this time. The address in the complaint appears to be correct, and Ms. Pruitt is eligible for public defender services.
Okay, thank you. And state of a position on bail.
1 second, sorry. Before I guess continue, I have a statement from the victim that they've asked me to read aloud on their behalf. They state that they agree with a no contact condition and a condition that Ms. Pruitt not use or possess any weapons, but requests higher cash bail and a ban from the 1000 block of Wilson Street due to the violent nature of the attack. Victim reports having been stabbed in the neck, face, head, eyelid, and arm, and was not aware of all of the numerous wounds at the time that the original police report was made, and was not able to go to the hospital due to her children being at home. The victim does not want Ms. Pruitt back out in her community. 1 second. Okay. So the state's recommendation is a $500 cash bail. I'm requesting that the defendant not use or possess any dangerous weapons as that's defined by the Wisconsin statutes, and that the defendant have no contact with Ephemia N. Their first name, Ephemia N. Their first name is spelled Efemia. It looks like this case involves an incident where it's alleged that Ms. Pruitt and the victim are hanging out at a food truck of some kind. A verbal altercation ensues. The victim tries to get her bag out of the defendant's car, who then speeds away. It's then alleged that Ms. Pruitt goes back to the victim's house because their kids are there. And then Ms. Pruitt runs in, grabs a fork, and then starts stabbing the victim. There are injuries mentioned in the police reports, but it's not the kind where stitches are involved or anything like that. Nevertheless, this is a battery, use of dangerous weapon case. I was just briefly trying to look through Ms. Pruitt's history. She was previously convicted in 2022 of physical abuse to a child, along with disorderly conduct count around that same time. And then I believe there's no other criminal history that I'm aware of. I'm not also aware of any failures to appear on top of that. But I think given the relative violence that's involved here, I think that some cash is appropriate. I agree with the non-monetary conditions.
And I'm not sure I totally caught it. Did you say the prior record was a disorderly conduct, or was there an additional charge?
There was physical abuse to child.
As a conviction?
Conviction, yes.
Okay, thank you. And Mr. Kavanaugh?
Yes, thank you. Looking Looking at those cases, I see that they were 2022 CF 72 and 21 CF 1990. Both charges felonies. You can see that from the title, I suppose. Both were cases, therefore, with prison exposure, but Ms. Pruitt received a signature bond and had no missed appearances. So we know that even with felony exposure, Ms. Pruitt will take the orders of the court seriously and show up out of custody for court on a signature bond. She takes that order seriously. With regard to the need for cash in order to make her appear, I don't think that's really a factor. I understand this is Act 3 eligible. Looking at the events in the case, this does not appear to be, even by the allegations of the state in the complaint, somewhat like a random attack on a random stranger. It appears that these people knew each other. I think a no contact and non-monetary conditions of that no contact and of no possession of dangerous weapons would be more than sufficient to protect this person and the community from danger from Ms. Pruitt. I don't think cash is going to be necessary here. A high cash would be impossible to post and disproportionate. A low cash is just going to make it such that if Ms. Pruitt didn't qualify for public defender services because she had more money, she could get out and be in the community. This is not a situation where the dangerousness is so high that we need to keep her in. I would ask for a signature bond in this case. We know that it's worked before.
All right, thank you. And any response from the state?
I should mention that physical abuse of a child intentionally causing bodily harm is contrary to 948.03 sub 2 sub B. When I'm looking at the Act 3 statute, that appears to be an included qualifying offense. So, and that's a relevant factor under an Act 3 analysis. I think what's different today is the fact that we have the Act 3 statute with Ms. Pruitt, which I don't believe was in effect back then. Furthermore, I agree with counsel that this isn't a random act of violence on a stranger. It's against someone that Ms. Pruitt knows, and that's the potential for victim intimidation is another consideration under the Act 3 analysis. It's a misdemeanor. I recognize that. I think the $500 balances the Act 3 considerations here.
I don't normally hear the words stabbed or stabbing and misdemeanor battery in the same sentence. So I need to take a second to look a little closer at the complaint. And I do see count 3 as a misdemeanor theft count. Is that, I guess I assume that relates to the fact that the alleged victim had some belongings in the defendant's car when the defendant left.
One second.
I mean, it's probably sufficient for probable cause, but I just don't. I'm trying to figure out if there's something else that I'm missing about that.
I know you're not asking me, but not to my knowledge.
I was guessing that would be your answer.
One second. Yeah, I believe so. So it looks like, right, as she tried to talk with the defendant about getting her items and bags out of the car, the defendant tried to speed off. Right. So yes, I agree, Commissioner. I believe that's what the gist of that is about.
Well, I'll let you all sort out the intent to permanently deprive element at some point in the future, but for probable cause, it's probably there. Let's start with what I think can't be denied. It is an Act 3 eligible offense, both because it's a battery and because it's charged with the weapon enhancer. Either one would be sufficient to trigger that. As noted by the state, that means that I'm supposed to consider the totality of the circumstances to include prior convictions for violent crimes. My understanding is that she has 2 prior convictions, one for a misdemeanor disorderly conduct. It appears that was resolved on a joint recommendation for a $100 fine. The other, the more serious one described by the state from 2022, I believe, or maybe 2021, was a straight probation disposition for which the defendant successfully completed probation. still a conviction, still counts in the analysis. But her performance after having been placed on probation seems positive. And I think I'm also supposed to take that into account. I don't know that there's much of any appearance of risk here. I really haven't heard strong arguments or maybe any argument in favor of that factor as being a significant one. Undoubtedly, when somebody is charged with a violent offense, there must be some concern about safety. That's present. Then it comes down to what does setting a cash bail do to positively affect that risk factor? A $500 cash bail is what it is. It's probably achievable. It's probably going to result in release. It's probably not that likely to dramatically affect behavior or make the community as a whole or Athenia N safer. I do recognize that Athenia M through the DA's office and the statements here today is stating a position that perhaps some higher bail would actually be appropriate. The irony here is that would probably better achieve the protections under Act 3 than what's been proposed by the state. But I also have to consider the appropriateness of it against misdemeanor battery charges. The prevention of witness intimidation factor, as the state notes, while present, as the state notes, I think is present. It's not an overwhelming one in this particular case, I don't think. I also have to consider any affirmative defenses without making any statement here about what occurred, because I don't know, other than what I see in a criminal complaint. When there's a confrontation, a physical confrontation between individuals, it's not difficult to imagine how there could be potential affirmative defenses at play. This is really a long way of saying I think this is a very close call, and I don't think there's anything unreasonable about the state's position. I also think a request for a signature bond in this case is reasonable, and I think it's workable. And in that situation, I have to go with that. So I'll order a signature bond. I am going to order as conditions that she's not going to have any contact with Athenia N, and also that she not go armed with dangerous weapons. Part of what I consider here, I think, is the fact that this is charged as misdemeanor offenses. Had this been some sort of a aggravated battery or reckless endangerment case or something like that as charged, I think the cash bail will probably be right on the money, so to speak. But she faces misdemeanor level exposure, and I have to factor that in. So I'll order the signature bond. Those will be the conditions. You do not want to mess with those conditions. Don't have contact with her. Don't be around her. Don't get caught with weapons. If those things happen, they're going to have a pretty strong argument for cash bail and probably in some higher amounts. And so I'll leave it at that, but hopefully you have that message. So we'll get a not guilty plea entered for you, Ms. Pruitt. I sure hope things work out for you and of course for the other individual too. Take care.
Menzel is next, via Zoom. Here.
All right, I think we're ready to call the case of the state versus Katie Menzel, case 26 CM 1102. Appearances, please.
The state appears by Assistant District Attorney Thomas Valerio. I appear in person.
And I believe Ms. Menzel appears by Zoom. Ms. Menzel, would you give us a wave to just indicate you can hear us? Thank you. Ms. Menzel appears by Zoom video from the Dane County Jail. Here in the courtroom for her attorney, Clayton Kavanaugh. It appears, before I move forward, that she does not want SPD representation and is seeking or has already sought a private attorney by the name of David Anderson.
Well, I wonder if the deputy could just unmute her so we can communicate about that. Okay, Ms. Menzel, can you hear us okay?
Yes, I can. I tried to get a hold of him, but my husband took my phone and everything, so I couldn't get a hold of my attorney until I get
Okay.
home.
So,
So
well,
it's fine.
yeah, the sad part about that is he was literally just here about 20 minutes ago, but he's now gone. Yeah, well, here are some options. Yeah, Mr. Kavanaugh's here. He works for the Public Defender's Office, and I know that he'll be happy to represent you at this hearing and make arguments on your behalf.
Yes,
If,
please.
yeah, and I think it makes sense to proceed that way because then you have an opportunity to get this looked at here today.
Yeah,
The other alternative, and I want to offer it to you potentially, is that you could ask for me to continue this to Monday afternoon to buy you some time to try to get in touch with Mr. Anderson and get him here. But then you aren't gonna have bail reviewed between now and then.
I don't want to stay in jail. I'm off my cardiac meds right now. And I
Okay,
had to go to the hospital yesterday.
all right, well, I think you're saying you want to go ahead with Mr. Kavanaugh, and I think that's a good choice. That you'd still always have the right to get Mr. Anderson on board after today.
Sure.
Yeah, okay. Well, great. So, Ms. Menzel has, an open misdemeanor case. It's assigned to Judge Hilton. Looks like it's 4 counts of restraining order violations. Not the new charge, I mean, the underlying one. What's the state's position regarding bail on this?
I'm recommending a $500 cash bail in this case. For conditions, I'm asking that the defendant have no contact with Tim M, that the defendant not use or possess any alcohol, and that the defendant be banned from the 3200 block of Happy Valley Road in the village of Windsor. My understanding is that the case you just referenced in your opening remarks was filed not too long ago. I believe that was in January of this year. Here it's alleged that Ms. Menzel is already violating a condition of that bond. I believe I think it's the violation of the no contact. I'm just trying to make sure really quick. But nevertheless, the underlying conduct ensues, which is also in and of itself a violation of bond. And this is technically an Act 3 eligible offense with the misdemeanor battery as an act of domestic abuse. So given the fact that Ms. Menzel is violating conditions of her bond so close in time to when the bond was set, I think that some cash is appropriate. I will note that Ms. Menzel has had a history of being able to post cash bail. It looks like there was $2,000 cash posted in December of last year in 26 CM 152. And then there was another time in 2024 where Ms. Menzel had $650 cash successfully posted in a case that's now titled 24 FO 2385. I'm not aware of any missed court appearances, and just trying to check really quick. I'm not aware of any Act 3 eligible prior convictions.
Okay, and well, I'll hear the defense position. I may have some questions about the factual allegations.
Sure. So I would ask for a signature bond in this case. The kind of general basis for it is true that she does seem to have an ability to pay cash bonds, even in the amount of $2,000. However, that's not what's required to get her appearance in court. For that factor, we can see that actually that bond was amended down to a signature bond in February 19th, 2026. So just about, it looks like 2 months after that cash was originally posted, it was amended to a signature bond. She then, on that signature bond, has not failed to appear, as far as I can tell. So in that case, signature bond was all that was required. I can't speak to the cash bond posted in the now FO case. I'm not as familiar with that, and I can't see as much of a record. Looking at the actual allegations here through an Act 3 analysis, I see, Act 3 offenses still exist on a spectrum of behavior. Even though it's Act 3 eligible, I think that the severity of that still matters. And as I look through the complaint, I see a reference to the alleged victim in this case stating that being struck by the defendant, quote, stung and caused him pain. This isn't a situation like some batteries that we've seen very recently, even where there is some significant kind of harm and damage. This is a situation where, at least on the spectrum of batteries, stung is lower on the end of that as a descriptor, at least. So in the severity of the actual battery, I think we're looking at far from a maximum here. It looks like she's never been, as far as I can tell, convicted of a crime before. This is, she has that open violating a restraining order. All this to say, I think a signature bond would be appropriate combined with non-monetary conditions. I understand that right now what we're looking at is a violation of bond. I think the repercussion for that, and an appropriate one, is a bail jumping charge. I think a cash bond in this case is not going to be necessary, given the factors that we've talked about. I'd ask for a signature bond for Ms. Menzel.
And I'll certainly give the state an opportunity to respond before I make a decision, but I guess I'm trying to put together the factual scenario a little bit. If I understand this, Ms. Menzel is out on that signature bond that was described on the multi-count complaint involving injunction violations. The injunctions have since expired, but there's a condition of bond in the pending case to not have contact with the person with the initial CM. And then this complaint alleges a battery to a different individual, but in the presence of CM. Yet I don't see that there's any actual charges related to violations of the no contact condition or anything to do with CM in this complaint other than as a witness. I guess I want to make sure I'm following the chronology and the sort of the procedural history correct.
The way that we charged it was we charged one count of misdemeanor bail jumping for the violation of the no new crimes condition.
And the currently requested conditions are, was it no threats or acts towards TM or what? Can you read? I know there was not to be in the 3200 block of Happy Valley and not to drink, but I thought there was an additional condition.
There was, oh, I apologize. 1 second. Let me get to the right page. It was a no contact with Tim M. And then the no alcohol, the address ban is what my conditions were, or what my proposal was.
Okay. And then if you had a response to the defense argument, you're certainly welcome.
I have nothing further to add.
Okay. She's out on bail on several Act 3 eligible offenses. She's charged here with an Act 3 eligible offense to a different person while allegedly committing that act in violation in the presence of somebody she's not supposed to have contact with in the first place. Given the bail conditions in the other case, I think the state's position with respect to the bail request is a reasonable one. I'll adopt it. I'll set cash bail at $500. She's not to have contact with Tim M, not to be in the 3200 block of Happy Valley Road, and not to consume any alcohol. I know that's more than Ms. Menzel was hoping to have happen here today.
Commissioner, she wants to say something again if possible.
Well, Ms. Menzel, I won't stop you, but I should at least caution you that we have a court reporter that takes down everything that's
I
said.
understand that, but my husband has cut off all my money. The CMs that you're talking about, one is Carly Menzel, one's my daughter, one's my sister-in-law who has the restraining order that's almost over, Christy Menzel. And they're two totally different people.
That may be very relevant information. A little tough to tell.
I can't get my heart medication and my bipolar medication in here.
And, well, let me see if
I'm trying to go to rehab is what I'm trying to do right away.
Okay. And let me see if the state agrees that these are different people we're talking about with respect to the CMs, because I think that does make some difference and I appreciate you correcting it.
So I apologize. I probably wasn't following quite, but what I can tell you is that the individual was Carly M. Is the
witness.
Correct.
Okay.
And yes, Carly M is the witness here in the case that we're having an initial appearance for.
Okay. And just for the sake of completeness, I believe Christy M is the person who previously had the injunction and now is the subject or the protected person in the bail condition in the earlier case.
Yes, so that's correct. Upon further review, upon pointing that out in 26 CM 152, the named victim is Christy M, not Carly M.
It's almost like this would be less confusing if we didn't use names. Mr. Kavanaugh, anything you want to add in response to that information?
I think the court kind of knows where I would go with that. I think that's pretty relevant information. She's not violating that injunction now, and she doesn't have contact with the no contact. Although there's new allegations of violence here, I think it does change that analysis quite a lot for it to be a different person.
Yeah, I think it tips the balance in favor of release. It's the factors I identified about her being out on the Act 3 offense and picking up another one are still present. They're still concerning. I think I put a lot of weight on the assumption that the CMs described were the same person, particularly given the earlier exchange during the arguments. But I think that tips the balance in favor of a signature bond. It's close though. Ms. Menzel, I'll order the signature bond, same conditions that we just talked about. You really, really want to make sure you're not violating these conditions, because I think if you got picked up on a third case, it's pretty likely the state's gonna ask for cash bail, maybe a higher amount than what they requested here today. And I think they're gonna have a pretty strong argument in favor of it, as you saw, because with the earlier information I thought I had, I thought it was a pretty strong argument today. So I hope it works out for you. Good luck.
Webster is next. John Webster.
Sean Webster, yeah, the paperwork. Stand on the yellow line, see.
Oh, it's Webster.
All right, why don't we call the cases of the state versus Deshaun Webster? Their cases 25 CF 2708 and 26 CF 1086. Appearances, please.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Webster appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading at this time. The address in the complaint could use an update. That's 3201, you said? The updated address is 3201 Ridgeway Avenue. Apartment D. That's Madison, Wisconsin, 53704. Mr. Webster is eligible for public defender services.
Very good. It looks like Mr. Webster is in custody on an absconder warrant related to some cases that had previously been handled by Judge McNamara. By local court rule, these cases have to get assigned to that same judge.
I'm sorry to interrupt. We do have two cases on for Mr. Webster this afternoon. One of the cases, there is a co-defendant. The co-defendant's version of that case has already been assigned to branch 3 Judge Flipper, and it looks like Mr. Webster is also on supervision of branch 3, so.
All right.
Both cases can be assigned.
That makes perfect sense. I appreciate the correction.
Eluding case.
Do you need a copy of the other complaint, and which one is it?
No, I do have it now. I see that. So I had in front of me before the fleeing and eluding complaint. I now see under what I just assumed was a thick complaint, another complaint for the possession of a firearm by a felon carrying concealed weapon possessions. We received that one as well. We can waive its reading.
Great. And state of a position on bail.
So in 25 CF 2708, I'm recommending a $1,000 cash bail with the condition that the defendant not use or possess any dangerous weapons and that he not have any contact with I believe Andeon H. They're the co-defendant. Their first name is spelled Andeon. And then
And the last name's Howard.
got it. And then for the 26 CF 1086 case, I'm requesting a $10,000 cash bail with the condition that the defendant not operate a motor vehicle. All right, so my understanding is when we're talking about the flee and elude case, the complaint in that matter alleges that Mr. Webster fled from law enforcement 4 times and was absconding from supervision since January 26th of this year, which is about the time that Mr. Webster had an arrest warrant out for a failure to appear on January 29th, 2026. Then the 25 CF 2708 is an instant date of April of 2024. And it's a serious case. I'll note that in the past, Mr. Webster has been convicted of possessing a firearm as a convicted felon. He's also been previously convicted of second-degree recklessly endangering safety in 20 CF 100. That's in 2022, and that's in believe, one second. That's an Iowa County case. And this is an act re-eligible offense, technically, but I point those out because of the high risk of exposure involved in a case like this. The fleeing and eluding necessarily, I believe, indicates an unwillingness to appear for court. And I think it's pretty unusual that Mr. Webster, I think you can piece out in the complaint for discrete instances where Mr. Webster flees from law enforcement. It's no better that he was absconding from supervision while this offense was occurring. So I think that substantial cash throughout the cases is appropriate.
All right, thank you. Mr. Kavanaugh?
I think that given the history and the allegations in the complaint, this isn't an argument really about signature bond or cash bond. It's an argument about reduced cash here. Mr. Webster is eligible for public vendor services, and the amounts of cash that have been requested here are going to, I think, quite frankly, be outside of his reach. I think that it's possible to both protect the public from the allegations of firearm possession and such, and assure his appearance in court with a lower amount of cash bond. I guess I won't throw a number out because I don't know Mr. Webster's ability to post beyond that he's eligible for public defender services, which means it's under federal minimum wage level of income. And he has a probation hold, which I think is also relevant. If he his agent will be able to make an informed decision, given all the facts and his history, about whether to release him from that hold as well. So I think that's another factor about why he's not as much of a danger as someone without that hold, without that additional oversight. So I would just ask for a reduced amount of cash bond.
I see what the state's requesting is the very minimum that would be appropriate here. I left to my own devices entirely, I might well have set a higher cash bail on these charges than what the state is asking for. It's pretty concerning that Mr. Webster's been an absconder for a period of time. One of these offenses involves an allegation of an unlawful use of firearm while on parole, and I think while on a GPS bracelet from a prior conviction for felon in possession of firearm. It ordinarily wouldn't be a stretch to think that he'd be a pretty good candidate for federal prosecution, given that record and the drug record that's also described in the complaints. The gun case is said to have happened a couple of years ago, so I suppose if he was going to get indicted, that would have happened by now. And that causes me to take the numbers a little bit closer to what the state suggests rather than something substantially higher. I also have to consider the flight aspects of both complaints. He has the benefit, I think as described by Mr. Valerio, of being charged with half the number of eluding counts as what's actually alleged factually in the 1086 case. And that gives me just so little confidence of a likelihood of appearing in court without a substantial cash bail on the line. So I guess I'll take the state's bail recommendation as mitigation and set cash bail only at those amounts. I'll set it at $10,000 in case 26 CF 1086 with a no driving condition. And in 2708, I'll adopt the $1,000 cash bail with the no weapon condition. And he's also not to have contact with Andy on Howard. Mr. Webster, I'm sure you're aware of this, but really your hold and what happens with that supervision is probably the bigger issue right now than the bail, because even if you posted the bails, you wouldn't be able to be released. But what we'll do is we'll get you scheduled for a prelim right away. That gives you an opportunity to get bail reviewed again as well. If you had a question, I'm happy to answer it. I want you to also, they'll be aware the court reporter takes down stuff. And sometimes people say stuff and it just gets used against them later. If you want to take a second to chat with Mr. Kavanaugh, that's cool too. Okay, if we're good, you're good for today. Good luck to you, Mr. Webster.
Garcia is next.
Garcia.
Let's call the case of the state of Wisconsin versus Herman Garcia, case 26 CF 1080. Appearances, please.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Garcia appears in person in custody with Attorney Clayton Kavanaugh. I will notify the court, however, that Mr. Garcia does not want public defender representation and declined to apply with our office.
And certified interpreter Fred Svensson is here. Mr. Svensson, do you swear or affirm that you will truthfully and accurately interpret the proceedings?
Yes, I do.
Okay, thank you. Let's talk about your right to a lawyer, Mr. Garcia. You have a good one standing right next to you there who will represent you for free today. If you want to take advantage of that, I think that's a good idea. You would always still be able to hire a lawyer on your own or choose to represent yourself later on if you wanted to do that.
Yes.
If you'd like to represent yourself here today, you're also welcome to do that.
I think he can represent me today.
I think that's a great choice. And then you can
When there.
always make whatever decisions you want from here with respect to that. The yellow sheet of paper you're holding describes how you would apply for a public defender later on if you decided to pursue that. You'd also always be free to hire a lawyer on your own or represent yourself. Does the state have a position regarding bail in this case?
The state's recommendation is a $2,500 cash bail with the condition of no contact with Carlos O. or Liberio O. Their first name is spelled Liberio. I would also ask that the defendant be banned from the 900 block of West Badger Road and any other place occupied by either victim in this matter. I would ask that the defendant not use or possess any dangerous weapons and that he not use or possess any alcohol. I'm not aware of Mr. Garcia having any criminal convictions or missed court appearances for that matter. But this is an Act 3 eligible offense, and it's a particularly serious one. It's alleged that Mr. Garcia, while getting into an argument over money, allegedly, withdraws a knife and then cuts the victim's face from the eyebrow to the lips. Lips. I recall the nature of some of the steps taken to treat the victim in this matter. It's alleged that the hospital staff had to cauterize the victim's wound at first, and that the laceration required approximately 200 stitches to close. And I believe it's toward the end of the criminal complaint. You'll notice that it's alleged that the incident is captured on camera. So it's a relatively strong case considering. So I think that given the gravity of this offense, I think that cash is appropriate.
Mr. Kavanaugh.
Yes, I'll start by referencing the public safety assessment that was submitted for Mr. Garcia in this matter. It indicates the appropriateness of a signature bond in this case. That's the recommendation it makes, even considering the charge of first-degree recklessly endangering safety. It points out, much like the state pointed out, that there is no prior record whatsoever. And that's not just due to his youth. He is, by my calculation, 24, 25. Which means there's been several years of being an adult that something could have happened and didn't. There's no indication that he will attempt to flee or fail to appear. And the non-monetary conditions of no contact, no possession of dangerous weapons, and no use or possession of alcohol seem sufficient to protect the community, as alcohol seems intrinsically intertwined with this offense. We had asked for a signature bond in this matter as recommended by the PSA.
And because I can see it on my computer, I don't want to hide it. I want others to be aware of it so that there's an opportunity to respond. The CCAP record for our county does not show a prior criminal record for Mr. Garcia, as has been described by everybody here. It does contain a family court case for which there was one appearance that didn't occur.
Hmm.
Yeah, it's a civil proceeding. It's not like somebody's necessarily in trouble for not appearing at it. There is, though, from earlier this year, a series of non-criminal traffic citations, including a hit and run charge. Again, those weren't mandatory appearances. Though he was found guilty by default and has not complied with the payment orders. That's probably a minor point in the big scheme of things, but just because I saw it, I thought, and it isn't irrelevant. I thought I'd share it to give each party an opportunity to respond. Maybe we'll start with the state, and then Mr. Kavanaugh, I'll give you the last. If you wanted to add anything on that, or in response to defense counsel's arguments.
I think if there were bench warrants in response to criminal actions or further criminal convictions that were Act 3 eligible in nature, I'd be asking for a much higher cash bail. I think my number fairly balances the relative gravity of this offense with the lack of criminal bench warrants issued. And I think my recommendations just made more appropriate by the record the court made.
And Mr. Kavanaugh, obviously I'll give you a chance to respond.
I would suggest the limited probative value of the information provided. And rest on the recommendation of the PSA.
And I tend to agree that the things that I identify are pretty minor points. They probably don't make or break anything one way or the other. They, to paraphrase Mr. Valerio, I suppose they're kind of the icing on the cake in terms of whether some sort of a cash bail is appropriate in the case. I honestly, when I see a case involving stabbing or slashing in 200 stitches, it's actually sort of surprising to me that we're talking about 4-digit numbers. That is the request of the state. I'm not going to exceed it in this instance. And I think that does take into account the fact that he does not appear to have a prior criminal record. That's to his credit. The amount that I've been asked to set as a cash bail is actually less than the amount that it's alleged was the cash that it's said that Mr. Garcia wound up recovering that triggered the whole confrontation. That's not the best measure of what a cash bail amount is, but it's in the mix. I'm not gonna set cash bail any lower than what the state requested. I think a persuasive argument could have been made for a substantially greater bail than that. I'll set cash bail at $2,500. The requested conditions of bond are appropriate. I'll order those. That he not have any contact with Carlos or Liberio O. That he not be in the 900 block of West Badger Road in Madison. And also that he not go armed with any type of dangerous weapon. He's
Sorry, Your Honor, you said two names. I only heard one, Liberio O.
and also Carlos O. I also failed to state the no alcohol condition. I do intend to order that as a condition. And then should we get him a prelim right away?
Yes.
I think that's fine. We'll get that scheduled. Good luck to you, Mr. Garcia.
Commissioner, did you decline I asked for a ban from any place either victim occupies?
I did not deliberately.
Sorry.
Yeah, we should be. I did not deliberately decline it. I overlooked it.
Okay.
It is also an appropriate condition and we'll include it.
Okay, thank you.
To not be at any place where those two individuals are. Okay, good luck to you, sir.
What proceeds for me now?
Well, we're gonna have another court date for you and we'll have some paperwork for you in the next room. If you can post the bail, you can be released. Good luck.
Euster is next, Jonathan Euster, and he was refusing to participate, forfeiture.
Well, I don't,
It looks like he's on video, so he's in seg 8, and I see door number 8 down there.
Okay,
Well, why do you spell the last name?
it's with an E.
It's a forfeiture.
Oh, that explains. Thank you.
All right. Okay, Deputy, is that Deputy Nordstrom there?
It sure is. So he does not
All
want to
right.
participate. He's sitting on his bed with his ears plugged.
Okay, great. We'll get a not guilty plea entered for him.
And then Dawson is next.
All right, we'll next call the case of the state versus, is it the Tristan?
Yeah, I just.
Tristan, Dawson, thank you. Case 26 CM 1091. Appearances, please.
the state appears by Assistant District Attorney Thomas Valerio.
And Mr. Dawson appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading. The address on the complaint appears to be correct, and Mr. Dawson is eligible for public defender services.
Okay, great. It looks like there is a hold. I believe that stems from some matters handled by Judge Genovese. That means that we need to get this case assigned to Judge. Well, normally it would mean we have to get it assigned to Judge Hilton, except the clerk tells me that the co-defendant's version of it's already been assigned to Judge Peacock. And because of the co-defendant rule, that trumps. So that's a real long way of saying that Judge Peacock's going to get assigned to this case. Well, what's the state's position regarding bail on this?
I have no objection to a signature bond in this case. I would ask that the defendant have no contact with the co-defendant, Lamart C. Kamen, that the defendant be banned from the State Street ban area per the ban map.
Okay. And the defense position?
That's fine with us.
And I'm just taking a look to see what the nature of the resisting was here. The clerk, I'll add also, the clerk advises that the DOC hold may have been dropped earlier today. Why is the signature bond appropriate, given the information on the bottom of page 3 going into page 4 of the complaint? Well, there's actually a little more on page 7 as well.
Frankly, I think we just compared both individuals' involvement in this matter, and I think the co-defendant had a more, I guess, noted history of obstructing law enforcement, so he asked for some smaller cash there. And I think we just noted that although, you know, obviously Mr. Dawson is on probation, which is an appropriate bail consideration, we didn't notice that prior history of obstructing or fighting with law enforcement. So I think we just compared the two and said, well, Mr. Dawson should get a signature bond given the circumstances and the co-defendant shouldn't.
Okay. Mr. Kavanaugh?
I think that sounds great.
I'm not totally sure I followed the logic of that, and it is kind of a doozy of a resisting obstructing type allegation. I recognize that Mr. Dawson is sort of under the thumb of the Department of Corrections in terms of supervision at this point. It's misdemeanor charges on the whole. We're not talking about extremely serious charges. I think this is one of those situations, Mr. Dawson, where I would probably have ordered cash bail if they asked for it. I think they did just solid asking for a signature bond. That's fine. I'll go along with it. We'll set a signature bond with the conditions that were requested. You'll want to make sure this works, because otherwise they're going to have really strong arguments in favor of cash bail, and then you'd sit here if you couldn't post it. Nobody wants that to happen, really. Good luck to you, Mr. Dawson. Take care.
O'Brien is next, Adrian O'Brien.
Turn me in one, please.
Adrian. Good one. You stay on the
All right, we'll next call the case of the state versus Adrian Okray. It's case 26 CF 1087. May we have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio.
And Mr. Okray appears in person in custody with Attorney Clayton Kavanaugh. We've received a copy of the criminal complaint in this matter. We can waive its formal reading at this time. The address on the complaint appears to be correct. Mr. Okray is not eligible for public defender services, but has already retained private counsel, it appears, but does want representation from the public defender's office for the purpose of this hearing.
Yeah, I think that's perfect. So he's gonna have you covered for today, Mr. Okray, and then you're certainly free to retain anyone you want or apply at the public defender's office in the future for this case. The other open case is assigned to Judge Kondar in branch 2. We should assign this case there as well. What's the state's position regarding bail?
I'm recommending a $500 cash bond in this case with the condition that the defendant not use or possess any alcohol. I think this is straightforward. Bail wise, Mr. Okray is alleged to have violated a specific condition of bond not to use or possess any alcohol. That bond condition stems from 26 CF 157, where it's alleged to be an OWI 4th offense along with the fleeing and eluding incident. He had to post $1,500 cash bail ordered $1,500 cash bail in connection with that event. And here Mr. Okray is violating one of the most important conditions of bond associated with that case, in my view, which is he can't use or possess any alcohol. And he's here causing a disturbance at a hotel. Law enforcement's called. They went to a room. He's visibly impaired, and he blows a PBT of 0.25. So I think that some cash is appropriate.
Mr. Kavanaugh.
Yes, I think that it's not wrong to say that it's one of the most important bond conditions to not drink in this situation, but the most important one is to appear for court. And looking at Mr. Okray's record, I see no failures to appear in any of his prior cases. He has 17 CT 613, 24 CT 42, and now his open case of 26 CF 157. He's never failed to appear in any of those cases, even when he had a signature bond. He's still not failed to appear in the other ones. I understand the concern about continuing to drink. I think it's notable in the criminal complaint that he's not doing it in a way that is dangerous. He's not reoffending with an OWI. He's not going out in the community. He's in a hotel, and certainly there's some belligerent behavior, but nothing that's dangerous or anything of that kind. The only consideration, given the non-Act 3 eligible offense here, is whether he's likely to appear in court and what cash is necessary to to make him appear in court. It appears from his entire record that no cash is necessary and that even signature bonds would be enough to assure that appearance. Again, I understand that we're concerned about drinking. The repercussion for that drinking can be modification of his bond in the other cases. And now he has the very serious repercussion of a new felony conviction, or very likely a new felony conviction. Cash in this case is not appropriate given the considerations laid out by the legislature. I would ask for a signature bond in this matter.
And any response from the state?
Well, his underlying case is an OWI 4th, and it's not your garden variety 4th. It's a fleeing and eluding 4th, and he's traveling approximately 70 miles per hour. He's engaging in dangerous behavior there. And so that necessarily indicates that Mr. Okray is going to have a hard time following court orders. And he's doing that here. He's not only violating his condition of bond not to drink, he's violating it a lot, where to the point where he's getting up to over a 0.2. So, I mean, on felony level OWIs, it's one thing for someone to pick up a felony bail jump for a no drink. I think it's worth mentioning the kind of OWI that Mr. Okray is charged with to demonstrate and impress upon him how important it is for him to follow this particular condition of not to use or possess any alcohol. And he's just doing that here. So I think that $500 fairly balances the fact that he doesn't have any failures to appear with the fact that he's violating a specific important condition of bail.
I just want to take a little bit closer look. honestly, I think both counsel are making all the appropriate arguments in support of their respective positions, and there's validity in all of them. There just is. I look at it like this, you know, and maybe this is a little more consistent with the state's view of it. He's not just out on bond on an operating under the influence fourth offense. There's an eluding charge, and that's probably a large basis for why. I don't know, because I don't think I set that bond, and certainly if I did, I don't remember the details, but I'm sure that the eluding is a major factor in why a substantial bail was set there. Honestly, reading the allegations in the complaint in that eluding and operating under the influence fourth offense case, I'm not even sure they're really garden variety allegations for those types of charges. There's some pretty scary statements and behavior described in those complaints about just the actual driving type behavior itself. No, probably related to substances. I think that's a reasonable inference, but that's all the more reason why those conditions of bond are appropriate. I'm glad to see this new offense didn't involve driving. That's a positive, I think. If I had to make a choice, I'd rather have somebody obviously be maybe violating a no drink condition at a hotel rather than with more driving. I don't know, looking at the complaint, that I see any evidence that he was like uncooperative with law enforcement or anything like that in this situation. At least it's not described there anywhere. That's to his credit. It's accurate that he doesn't, to my knowledge, it's accurate that he doesn't have the problems with prior court appearances or anything like that. And that, yeah, that also counts. Another way of looking at this, though, is when somebody posts a $1,500 cash bail and agrees to certain conditions, they're really saying, here's $1,500. And if I don't follow my conditions, I'm essentially asking you to take this $1,500. The state's not asking for that to occur. They haven't filed a request to forfeit that bond. They've asked that we set a bond 1/3 of that on the violation itself. And I struggle to find that unreasonable. I think that makes a lot of sense. There's probably something to be said for the logic that the purer way to do this would be to increase the bail in the underlying case rather than set more cash on the new case. That's just not the procedural steps that get taken in this county in terms of bails. The end result, though, is I think an appropriate one. It's again, it's a third of what he's posted previously. I'll set cash bail at $500. Oh, and I'll add one other thing about that. These are cases that would probably scream out for pretrial services if that were an available option, and that would help mitigate risk some, I think. I don't have it as an option because they aren't really doing any active monitoring right now, and they're not taking referrals that involve active monitoring. So I don't have that to rely on. But with that said, I'll set the $500 cash bail. I'll order the no alcohol condition. Mr. O'Cray, if you can post it, you can be released. You have other court dates. We'll get you scheduled for that stuff. We should talk about the time limits for that court date, though, Attorney Kavanaugh.
Since he is retaining private counsel, I wouldn't feel comfortable waiving them today, even with conversation. I would ask that we keep the time limits.
Sure, and that's fine. We will get it scheduled within 20 days, as permitted by statute. And this means, Mr. O'Cray, you're going to have 2 different court dates coming up. You're going to have the one that you have in your earlier case, which I think is in July, and then you're going to get one sooner than that in the next couple of weeks. You got to attend both. At some point, they'll match up. They'll wind up in the future running these things at the same time, most likely. Okay. Hey, good luck to you. I hope it gets better. Thank you. Sure. Good luck, man.
O'Hara is next. Daniel O'Hara is.
Dane O'Hara. Good work. Please stand on the gotaways.
Okay, we'll next call the case of the state versus Daniel Heron, case 26 CM 1096. Appearances, please.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. O'Haron appears in person in custody with Attorney Clayton Kavanaugh. We received a copy of the complaint in this matter. We can waive its formal reading. We have no update for the mailing address listed on the complaint. Mr. O'Haron is eligible for public defender services.
All right, thank you. Mr. O'Haron is well, I should say was in custody on a probation hold. Looks like that stems from some cases that had been handled by Judge Genovese. That means that this case has to get assigned to Judge Hilton pursuant to local court rule. I said that in the past tense because I believe that hold has been dropped since it was initially lodged. What's the state's position regarding bail in this new case?
I'm asking for a $500 cash bond in this case with condition that the defendant have no contact with Cameron H. It looks like as you, I believe, alluded to, Mr. O'Haron was released to extended supervision in January of 2026 after being convicted of multiple bike thefts and burglary. It's my understanding that while those cases were going on, he was violating bond while in the community with those cases pending. He's not on bond in this case. He is on ES though, and I think that's an important consideration. So given that, it's a property crime misdemeanor. I don't think a substantial amount of cash is needed, but if he's violating his ES conditions, I believe that some cash is appropriate.
Mr. Kavanaugh.
Before addressing my argument on bond, I would move to dismiss the charge. In reviewing the contents of the criminal complaint, I don't see any reference to any facts by which Mr. O'Haron should have known that this property was stolen. It appears that he bought a bicycle off of Facebook Marketplace, and I'll admit this is a rather cursory review, so maybe I missed something here, but from what I can tell, there's no indication that the bike was stolen. There's no indication that the person who was selling it told him it was stolen or that he knew it had been reported stolen or anything of that kind before purchasing it. It appears he did what a lot of people do, which is buy something kind of cheap off Facebook Marketplace.
So I may invite the state's response, but I guess maybe I'm reading this complaint differently. I don't read this complaint to say that it's alleged that the defendant bought the bike on Facebook Marketplace, but rather that he was marketing it on Facebook Marketplace when.
Oh, I apologize. Yes.
Yeah, and then later in the complaint, there's a statement that the officer asked him where he acquired it and said that he bought it at Cabela's a year and a half earlier.
My apologies. Yes. So there's an indication that he stated where he had bought the bicycle earlier. Yes, I apologize. I misspoke. Was trying to sell it on Facebook Marketplace, not buy it. My apologies. Either way, I still see no reference to him knowing when he got it that it was stolen, even though he stated, I guess, where he'd gotten it before. I don't see any indication that he had knowledge that it was stolen when he received it.
Well, I don't have an ability to sort out whether CAH's account that the bicycle was stolen on May 7th is accurate, or whether the defendant bought the bicycle at Cabela's a year and a half earlier is accurate. But the fact that those things can't both be true, I think, creates a sufficient factual issue such that the motion to dismiss should be denied.
If I may, just briefly.
Sure. Yeah, absolutely.
I don't disagree that it was stolen property. And so I agree that there is a very reasonable inference that the bike was in fact stolen. But for Mr. O'Haron's knowledge that it was stolen when he received it, since this is not a theft, well, even with a theft charge, it would have to be that he in fact did steal it. But here I don't see any indication that he knew it was stolen when he received it. Not that it wasn't stolen.
All right, I'll take a bit closer look at the complaint, but I think the inconsistency between those events gives rise to an inference that one of those versions is incorrect. And if Mr. O'Haron's version is incorrect, it also yields the pretty strong inference that he would have known it was stolen. But I'll take a closer look at it. Yeah, I think the factors identified alone would could cause a reasonable jury to conclude that Mr. O'Haron's account is bunk and that he would have known that it was stolen based on that. That's not me deciding that. I don't know. But the issue for today on the motion to dismiss is whether there's some view of this that would allow the state to prevail. And I think that alone would do it. I also don't think it's, I also don't think that it's helpful to the defendant's sort of position in that analysis that the complaint also alleges that the photograph of the bike posted to Facebook Marketplace is in its original location where CAH says it was stolen from. There's certainly some circumstantial aspects to this case, but they're pretty strong circumstantial aspects. I'm going to deny the motion to dismiss. You'll sort it out later, and the defense or the state does have to prove this beyond a reasonable doubt. I should turn to the defense position though regarding bail.
Yes, yes, thank you for your patience on that. With regard to bail, I would ask for a signature bond in this matter. As was stated before, it's a property crime. It's a property crime for under the felony level, so it's a misdemeanor property crime. And Mr. Heron is currently under supervision, which just to me indicates that if there need to be repercussions for this, there can be immediate and quite potent repercussions. I don't think that it's likely, even given his record, that he's going to be spending significant jail time for this minor property offense. And almost certainly a cash bond would, given his eligibility for public defender services, accomplish that. I'd ask for a signature bond.
Any response from the state?
I agree, it's a property crime. Problem is that Mr. O'Haron wasn't on bond, he wasn't on probation, he was on extended supervision when he allegedly committed this offense. And I believe it's alleged that he's on ES for stuff that's also property crime in relation. There's not a huge amount of exposure in this case because it's just a misdemeanor. It has the repeater enhancer on it though. Still, he committed it while he was on ES for largely similar conduct. I think some cash is appropriate.
It's debatable. I think there's arguments on both sides of it because as identified by the defense, this is not an Act 3 eligible offense. Appearance risk is supposed to be a major factor. I do also have to take into account, I think based on some of the language in chapter 967, in addition to 969, but in 967, I think there's language suggesting that it can be appropriate to set cash bail if necessary to assure compliance with conditions of bail. And there's the history of a whole slew of very similar allegations a couple of years ago, including multiple violations while on bond. Doesn't bode real well for success upon release. I can't put a lot of weight on the probation supervision tie because the hold's already been lifted. It was 5 days after he was taken into custody. So I don't know that the risk of immediate consequence is necessarily as strong a factor here as it might be in some others. It's, I also made the observation I did earlier about the apparent strength of the allegations in the complaint from an inference perspective or a substantial circumstantial evidence perspective. It occurs to me also that those allegations would not be any weaker if you started to get into another acts analysis, which would almost write itself in terms of a motion on that, given the other history. I don't know whether that motion's going to get filed. I don't know whether it would be granted, but I think the state has a pretty strong case given all of that. I'm going to set the $500 cash bail. I'll order that he not have contact with Cameron H. and that he not, I'm also going to order as conditions that he not be on Facebook Marketplace or any other sort of internet-based sales platform. I'm further going to have a condition be that he not have physical contact with any bicycle. So Mr. O'Haron can find some other means of transportation given this pretty substantial history of what's alleged in this complaint. Mr. O'Haron, we're going to get you a new court date here in the next room. If you're not able to post the bail, I think they're going to be hooking you up with a lawyer who can file a motion and get that looked at. Good luck to you. I hope things get better.
Gordon, what's next? James Gordon.
James
Gordon. He's down in the elements.
I'm sure.
All right, we'll call the case of the state versus James Gordon. It's case 26 CT 351. Appearances, please.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Gordon appears in person in custody with Attorney Clayton Kavanaugh. We received a copy of the criminal complaint in this matter. We can waive its formal reading at this time. I don't have any update for address. Is that correct? When you get up?
Yeah.
Okay. The address in the complaint's actually right. I don't have information about his eligibility for public defender services.
Okay, I believe he's serving some sanction time from some earlier cases. We will get this case assigned to the judge associated with those cases to the extent possible. I don't know if the clerk tracked that down.
Branch flag.
Okay, great.
But now they're charging us for it.
And then, did you say he does not qualify for a public defender?
We don't have any information. on
Okay.
that yet.
So, Mr. Gordon, I think you're holding the sheet there that describes how to apply for a public defender on this. You're also free to hire a lawyer on your own or to represent yourself. If they say you don't qualify and you still really can't afford a lawyer, there's also a process for applying through the clerk of court's office. He's gonna help you today. I think this was originally scheduled for an out of custody initial appearance yesterday morning, but Mr. Gordon's in custody and so we're handling it now. This, if you haven't put it together, this is the same thing that you would have got a ticket for with the court date yesterday. Yeah, so it's not new stuff. What's the state's position regarding bail?
Don't object to a signature bond. I would ask that the defendant not operate a motor vehicle.
Any objection to that?
No.
I think it's reasonable. Let's do a signature bond with that condition. We'll get you set with another court date, Mr. Gordon, and then this isn't going to affect the rest of your sanction at all. You'll serve that and be on your way, but you probably will have court dates after that.
Okay.
Good luck to you. Take care.
Cardinal, Cardinal for.
Oh. Cardinal Corporate, hell yeah.
Pardon? Paperwork? You just gotta like.
All right, we're next to call. Oops, right there. There you go. Right there with that. Yeah, you got it. Yep. Do you need us to speak up?
Yeah, I'm half deaf.
Okay, let's call the case of the state versus Kyle Cardinal. It's case 26 FO 854. Appearances, please.
The state appears by Assistant District Attorney Thomas Valerio. The defendant Kyle D. Cardinal appears in person without counsel.
All right, and Mr. Cardinal, if you have trouble hearing, please let us know so we can try to fix that.
Yeah, I was a musician and my ears are shot playing guitar.
Understood. So it looks like the DA decided not to charge you with a criminal offense. They charged you with an ordinance violation. It's like a ticket for disorderly conduct. You can enter a not guilty plea to that. If you do, we'll let you out of jail. You won't have to post bail. Then we'll just give you another court date later on. That would keep all your rights alive.
Right.
If you want to try to resolve the case here today, they probably have an offer for a fine to do that. Do you want to hear that offer or do you prefer to enter a not guilty?
I prefer to hear an offer.
Fair.
It would be court costs only.
All right, so it would be $114.50 if you wanted to accept that.
I can't pay it today though, sir. I'm on Social Security and I don't get paid till the first of the month next
I
year.
understand. We would give you a couple months to pay it, or if you needed longer, you could apply for a payment plan.
Okay, I'm cool. I'm cool with that, sir.
Okay, great. I'll take that as a no contest plea to this non-criminal charge. We'll find you guilty of it. The total is $114.50 and we'll have some paperwork for you next door.
Okay,
Good
sir.
luck to you.
Thank you.
You're welcome.
You have a good day.
You too.
Alonso, Samuel Alonso, then.
All right, let's next call the case of the state versus Samuel Alonso. It's case 26 CF 1079. Appearances, please.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Alonso appears in person in custody with Attorney Clayton Kavanaugh. Just one moment, I'm sorry. Just because you're right. Don't mind asking. Do you want to just want to make sure I don't want to be disrespectful. Okay. You're in the courtroom for him, Attorney Clayton Kavanaugh. I just was having a brief conversation because Mr. Alonso either has or is planning on getting private counsel and doesn't want SPD, but is fine with me representing him here today. We've received a copy of the criminal complaint. We can waive its formal reading at this time. That's correct. The address in the complaint is correct. And I've noted already his private counsel.
All right, thank you. He does have two open felony cases that are assigned to Judge White. We'll get this case assigned to Judge White too. What's the state's position regarding bail?
I have no objection to a signature bond, and I would ask that the defendant not use or possess any dangerous weapons.
That seems fine with us.
Okay, third case, it's pretty unusual to get a signature bond in that situation. I'll go along with it, but I think you gotta make this work. Let's do a signature bond with the no weapon condition. What about the time limits for preliminary hearing?
We'll keep him for now. Let his private counsel handle it.
Okay, we'll get it scheduled within 20 days. Good luck to you, Mr. Alonso. Take care.
Thank you.
You're welcome.
Riley is next, Ishmael Riley.
Right? There you go. You stand in the middle of this. All right, we'll call the case. This is Ishmael Riley. It's case 26 CF 1082. Appearances, please.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Riley appears in person in custody with Attorney Clayton Kavanaugh. We received a copy of the criminal complaint in this matter. We can waive its formal reading at this time. I don't have an update to provide the court regarding address. He is eligible for public defender services. I have a motion to bring, but I can do that in the middle of bail or whatever we'd like to do.
Well, maybe now. Is it just as good a time?
Wonderful. I will bring a motion to dismiss both the burglary charge and the possession of burglary as tools charge. The basis for that is in reviewing the criminal complaint, this one a little bit more thorough, I believe, than prior. I see reference to entering what appears to be Mansfield Residence Hall at about 1:30 a.m. But immediately upon entry being spotted and then leaving. I see that as a trespass, certainly. I even see that as potentially criminal damage to property as is charged here, as the door appears to have been damaged in the process, but nothing here indicates an intent to steal. The burglar, of course, being charged as such. I think that's relevant because essentially what the facts are is simply a criminal trespass to dwelling. There is no indication of, again, theft or anything of that kind or intent to commit a felony. Finding probable cause simply based on the trespass itself would transform every single trespass charge into a burglary itself. There's no indication this is anything but that trespass. The tools then being necessary kind of have to infer a burglary in order to have those tools, that tools charge. Would also then, I think, be inappropriate to have in this complaint. For that reason, I'd move for dismissal of both counts 1 and 2.
And any response from the state?
1 second. So as what's outlined in the criminal complaint, it's alleged that according to surveillance footage, Mr. Riley is seen on video wearing a surgical mask and his hood up, walking into Mansfield Hall, or attempting to gain access into Mansfield Hall and using a shim in order to gain access to that lock. According to the video, the defendant tries the front door, it doesn't open. He then retrieves some sort of device from his left pocket, uses it to open the door, damaging the latch in the process. Mr. Riley, as it's indicated toward the bottom of page 2, at the top of page 3, is not a resident of the building, was not invited by anybody. The lock was damaged such that it caused $300 to $500 worth of damage to fix. And then toward the middle of page 3, it states a stranger used some sort of shim to break and enter our building through the locked front door. The stranger was seen through a ring camera using a credit card or shim to break open the front door lock. They are a residence hall with more than 20 students living on site. The man appears to enter the building where students report seeing him. And then they find Mr. Riley later on, I believe at a Quick Trip, as it's alleged toward the middle of page 3, where he's found to be in possession of several financial cards located on him with different names. Look, I think that the incident here indicates that Mr. Riley attempted to gain access into Mansfield Hall, which is a student living facility, 20 students living on site, according to the complaint. He's wearing clothing in order to hide his identity with the surgical mask and his hood up. He's using a tool to enter into the building. Just because he doesn't successfully steal anything, doesn't mean he didn't enter without the intent to steal. He's using a tool in order to gain access to this building where he is not a resident, where students live, where multiple students live, and he's doing so in a way that's trying to hide his identity. There's, in my view, no other discernible reason why he would need access or attempt to find access to the Mansfield Hall address. According to the facts in the criminal complaint, he doesn't even know anybody there. He's not a resident of the building, not invited by anybody. It's different from a case where he's attempting to trespass onto property with the intent to maybe stay there. But I think the circumstances, when looking at it through a probable cause perspective, I think there's enough to say he went in with the mental purpose to steal something.
Yeah, Mr. Chairman.
Thank you. I think that this is an oversimplification, and I understand that, but in some ways, I think what the state is arguing here is that a trespass alone is sufficient for an inference that there's an intent to steal, that covering one's face, going in, trying to enter this place, it itself gives the inference of an intent to steal. That would transform every misdemeanor trespass into a felony. I don't think we have enough here to indicate that there was any intent to steal. There was no, as far as I can tell, not just a failure to accomplish a theft. There's no attempted theft here. Just not even any indication of an attempt to steal. Not just a failure to do so successfully, but even an allegation that he attempted to do so. This isn't a situation where I'm arguing that he got in, but he wasn't intending to steal, and then he saw something and then he stole. There's no indication he ever did any of those things or intended to do any of those things. I don't think we can transform a trespass here into a burglary by the very fact of the trespass. I understand later he's found with credit cards that are not in his name. Those are not, as far as I assume that the complaint would have indicated that those belonged to the students if that had been something that was accomplished. Instead, it appears that either of those were in his possession before or after. I don't think possession of cards that we would have to infer he does not have consent to have. Then additionally give a second layer of inference that he would have then intended to steal from this place. I think we have a trespass, but we don't have a burglary.
I mean, he's not charged with a financial transaction card violation, but doesn't that statute like on its face allow one to infer that if you're in possession of somebody else's card, it's done with intent to defraud? It's not quite the same question as the one you're posing, and I acknowledge that.
Right. Sure.
So potentially a different crime that could be alleged from a couple of days later that hasn't been brought. It's not really a couple, it's like a week, 6 days later. So as has been identified with respect to the burglary charge, as it's currently charged, there would have to be some reasonable inference of an intent to steal. I say it that way because I know there's other potential intents that can apply in burglary cases, but that's not what's alleged in this complaint. The possession of burglarious tools charge probably largely rises or falls the same way because the tools described would have been the same devices used to commit the alleged burglary. It's a question of whether there are competing inferences of which one is consistent with the state's claims here. You know, of the universe of possibilities, there are many in terms of what the intent would be to enter the place. I suppose it could be to catch the late show on television in the student lounge. It could be just because it's a nice place to stay. Maybe, I don't know, maybe it was cold that night. There's a lot of potential possibilities why somebody might enter a building. One reasonable one, though, is if somebody's entering essentially a residential location in the middle of the night at 1 something in the morning, attempting to conceal their identity, again, allegedly, because that's an inference, because I don't know what was in Mr. Riley's head. I don't know whether he even did any of these things. That's the nature of allegations. But one reasonable inference would be if somebody's attempting to conceal their face through using a surgical mask, not in the COVID era, so to speak, wearing a hoodie with their hood up, and in relatively short time period afterwards is found in possession of items that were very likely not lawfully obtained or retained, that the intent could be to steal. I think this is another one of these cases where I think that intent has to be inferred if it's to exist at all in the absence of some sort of a statement, but it's a reasonable inference given these circumstances. Again, I mean, I could come up with a lot of reasons why somebody might engage in this behavior at that time. One reasonable inference, and probably the strongest one, is an intent to steal. I think I'm obligated to deny the motion to dismiss it as the counts 1 and 2. I will do that. Like any other decision, you know, that's subject to being reviewed by a circuit court judge, and at some point he's going to have the right to a prelim where the burden is slightly higher also, and that'll get sorted out. We should turn to the arguments regarding bail. It does not appear that Mr. Riley has any cases open, though it does appear that he's in the stay period of some sentences and is due to report to jail in June on a couple of other cases. Mr. Valerio, any position on bail from the state?
I'm requesting a $5,000 cash bail in this case for conditions. I'm asking that the defendant be banned from the state Langdon ban area. My understanding is that Mr. Riley was just sentenced in April of this year for entry into a locked building or construction site along with other charges. And it's alleged that in this case, Mr. Riley goes to the Mansfield Hall address and conducts the allegations set forth in the complaint in May of this year. So really not a whole lot of time between the time that Mr. Riley was sentenced on similar conduct and this case. Mr. Riley does have a long criminal history, though I'll state that a lot of it is property crime related matters and drug possession related matters. But you know, I'll note that Mr. Riley has several convictions of the similar type of behavior, uttering of a forgery, entering into a locked location, as I mentioned. There's another uttery of a forgery conviction in 2021 in Dane County. Actually, several convictions of uttering of a forgery, felony retail thefts, criminal damage to property. So lots of property related criminal convictions in the past. And I mention that not because, those are Act 3 convictions that Mr. Riley's been convicted of, but it increases his level of exposure here. Burglary is an Act 3 eligible offense. And here, even though Mr. Riley was just sentenced for similar conduct, he's still allegedly continuing to engage in that conduct. That's, I believe, concerning from a bail perspective. So given that, I think cash is appropriate. I think the ban is appropriate.
And Mr. Kavanaugh, the defense position.
Yes. I think one of the most important factors here is going to be the strength of the state's case. I think what we're looking at here, and I don't mean to relitigate the issue. I know that that's settled. But when we're looking at here with the issue of probable cause, the issue of burglary and the intent to steal here is thin based on as far as we can tell. The only indication of, I guess, theft in general close by would be a possession of cards a week later. Not even the cards, I suppose, that from this place, as far as we can tell. Same with the possession of burglarious tools. The only felony conviction here appears to be somewhat threadbare. The only other offense I think that would survive, certainly beyond a reasonable doubt analysis based on what we know now, is criminal damage to property. That offense is not Act 3 eligible, though I know the ones that burglary is. Again, I think the facts of this burglary are relevant in that, even taking it at its worst, there was nothing actually taken or stolen. I do think it's relevant too, as I was reading through this complaint. If what appears to be a card of some kind can cause $300 to $500 worth of damage to a door, I mean, that conduct is minor, even with that amount of money. That seems frankly an unreasonable amount of money. But again, I don't know the facts specifically. All that's to say, as burglaries go, on the spectrum, it's low. Looking then at Mr. Riley's PSA here, I understand that he's rated somewhat highly in new criminal activity scale. I think that's consistent with what we've seen from the past from Mr. Riley. That's fair. The failure to appear is slightly lower. I think that most importantly, however, is the release recommendations from the PSA, taking all these elements into account, and it recommends a signature bond in this case. Certainly, the amount of cash bond in this case is far, far beyond the ability to pay of someone who can, someone like Mr. Riley, who is eligible for public defender and has a history of indigency. I frankly think a signature bond is appropriate in this situation.
And any response from the state?
So it looks like Mr. Riley, because of the recency of it, was sentenced to a jail sentence, which was a couple months, and didn't even make it that far without allegedly picking up this offense. And it's Act 3 eligible in nature. Even though he wasn't on probation, he was still under jail supervision rules at that time. So I think that just adds on to the state's concerns and further strengthens the need for cash in this case.
And I guess I do want to be factually clear. I don't think he was serving a sentence when this is alleged to have occurred. I think he was in the stay period from when he was sentenced to when he was to report to the jail.
I see.
Which really means his release was completely at the option of the judge and would remain so, presumably. It's an Act 3 eligible offense. I think it just is, and we recognize that. It's hard to know exactly how to characterize a burglary. If I were looking at it from a purely economic perspective, it's relatively minor here. There's no doubt about that in terms of the dollar amounts of damage that are alleged to have occurred as part of the break-in. I think most people would view the seriousness of a burglary a lot less related to the dollar value of items stolen and more the sense of security, the danger associated both to an offender and people who are present with respect to that. I think I already talked about the sense of security. So this is not, I don't think this is an unserious burglary. It's alleged to have involved going into a residence, but not just a residence hall with multiple students in it who in some ways maybe are more vulnerable than some other people, probably a little bit more trusting in terms of securing belongings, and not that anyone should have to take great steps to secure belongings within their own residence hall, but in any event, there's that factor. I view it as a relatively serious burglary if it can be proven, and there is the point about that, and I don't ignore that entirely. The fact that it's alleged while under the grace of a stay of a sentence for 2 other cases, I think makes this very clearly a cash bail situation, and I do intend to set cash bail. I struggle a bit with the $5,000 figure. I understand that perspective. It would be, I think, just purely preventative detention if I set it at that amount, given Mr. Riley's history and given what seems to be able to be known from looking at these documents. It also, in my opinion, is a bit excessive, given the fact that he has a very modest prior failure to appear history and not a significant violent crime history. He must have something, because the PSA does list 1 prior violent conviction. It hasn't been brought to my attention specifically, and maybe it's another burglary type charge or something. I'm gonna set cash bail here at $2,000. I'll have his conditions be that he not be at the state and Langdon ban area as depicted on the map that deputy's giving him. He should also give him a copy of the UW-Madison campus ban area, because he's getting that as a condition as well. And lastly, I'll order that he not be on the Edgewood College campus. In doing that, and I realize that's not the claimed location of what's alleged in the complaint, but I want to make sure that there are fewer target-rich environments that are out there, and for an individual who's 31 years old, and there's just not as much reason to have to be in those locations otherwise. Obviously, if something emerges where it makes sense for him to be on one of those campuses, he's free to file a motion to get this reviewed, and that's fine. Let's get not guilty pleas entered on the misdemeanor charges. I assume we should put on a prelim right away.
Yes, please.
Yep, we'll do. All right, Mr. Riley, good luck to you. Yes, thanks to all of you. Have a good